You know, we've all been there. Someone sells you on this amazing promise. You sign on the dotted line, and then that horrible sinking feeling hits you. I think I've been misled. Well, that exact moment is what this explainer is all about. We're diving deep into misrepresentation. What happens, legally speaking, when a false statement tricks you into a deal you wish you could just escape.
Right? Maybe it was a car that was supposedly in perfect shape, but then, surprise, it breaks down the next day. Or maybe some investment that was pitched as a sure thing and turned out to be, well, not so sure. That feeling is universal, but it also has a very specific legal name and a set of rules that go with it.
So, here's our roadmap. First, we're going to pin down what misrepresentation actually is. Then we'll get into what counts as a fact versus just someone's opinion. After that, we'll see why it has to have been the thing that made you sign. We'll explore the 3 different kinds of misrepresentation, and finally, we'll cover what the law can do to make things right.
Okay, let's kick things off with the absolute basics. What does this term misrepresentation really mean when we're talking about the law?
Let's break this down, because every single word here is important. It's got 3 key ingredients. Number 1, you need a false statement. Number 2, it has to be a statement of fact, not just an idea or an opinion. And number 3, that statement has to be the thing that induced you, that pushed you over the edge to agree to the contract. Of course, the law has to be realistic here. Not every single piece of sales hype is going to get you a lawsuit. There's a special term for this, mere puffs. Think of those vague, over-the-top claims. In a famous old case, some land was described as fertile and improvable. The court basically said, come on, that's way too vague. It's just marketing fluff, not a concrete promise.
And that whole idea of fluff versus a real claim, well, that brings us to a super important line the law has to draw. The line between someone just giving their opinion and them stating a fact.
These 2 cases lay it out perfectly. On the left, you've got a seller who's never farmed sheep on his land. When he says, I think he could hold 2,000 sheep, that's just an honest guess, an opinion. But on the right, you have a seller who calls a tenant most desirable even though he knew the tenant was broke. See the difference? Because he was in a position to know the truth, his statement wasn't an opinion anymore. It was a lie disguised as an opinion.
So what happens if someone doesn't actually lie? They just, keep their mouth shut about a problem. Well, the general rule is something called caveat emptor, which is just a fancy way of saying, let the buyer beware. Usually, a seller doesn't have to point out all the bad stuff. Silence by itself isn't misrepresentation.
But you knew there was a but coming, right? That's not the whole story. The law is smart enough to know that sometimes saying nothing is the most misleading thing you can do. The real question is, when does your silence cross the line and become a lie?
Turns out there are 3 really key situations. First, we have half-truths. You say, oh yeah, the property is leased, but you conveniently forget to mention that the tenants gave their notice and are leaving. That's a misrepresentation. Second, a change of circumstances. Let's say a doctor tells a potential buyer his practice is making a certain amount of money. That's true at the time, but then, before the deal is done, the practice falls apart and he says nothing. That failure to update the buyer is a misrepresentation. And third, you have what are called contracts of utmost good faith. The classic example is an insurance application. In these cases, you can't be quiet. You have a legal duty to spill everything that's important. Okay, so you've got your false statement of fact, but that's still not enough to win a case. Now you have to prove the next part of the puzzle, that this statement actually mattered, that it was the thing that induced you to say yes.
This all comes down to a simple idea, reliance. You had to have actually relied on that statement. Now, it doesn't have to be the only reason you signed the contract, but it definitely has to be one of the big ones. If you knew it was false and went ahead anyway, or if you did your own research that told you it was a lie, then you can't really claim you were misled, can you?
But here's where the law is actually pretty cool. What if you could have found out it was a lie, but you just didn't check? Well, the person who lied can't just turn around and blame you, saying, well, you should have done your homework. As this ruling clearly states, if someone tells you a lie to get you into a deal, you're protected. The blame is on the liar, not on you for being too trusting.
All right, now that we have the basic ingredients, we have to add one more layer to this. You see, not all misrepresentations are treated the same way. The law actually breaks them down into 3 different types, all based on what was going on in the head of the person who made the statement. And this is a huge deal because it changes what you can do about it.
So the three types basically run from an outright lie to just an honest mistake. On the most serious end of the scale, you have fraudulent misrepresentation. This is when someone knew the statement was false, or they were just totally reckless about whether it was true or not. They were trying to deceive you. In the middle, you've got negligent misrepresentation. This isn't a deliberate lie, but it's just plain careless. The person made the statement without any good reason for believing it was true. And finally, we have innocent misrepresentation. This is a genuine mistake. The person actually had good reason to believe what they were saying was true. They were just wrong.
So, it happened. You were lured into a contract by a false statement. The big question is, now what? What can the law actually do for you? Let's talk about the remedies.
The law really has two main tools in this toolbox here. The first one is called rescission. Think of this as the big undo button. The contract is basically torn up, you give back whatever you got, you get back whatever you paid, and everyone just pretends it never happened. The second tool is damages. This is just a legal term for money, a payment to make up for any losses you suffered because of the lie. Now, whether you can get that undo button or the money, or maybe even both, really depends on which type of misrepresentation it was, fraudulent, negligent, or innocent.
But, and this is a really big but, that undo button, rescission, it's not always an option. There are 4 specific things, 4 bars that can actually block you from being able to cancel the contract.
First, if you affirm the contract. This means you find out about the lie, but you just shrug and carry on with the deal anyway. You've lost your chance. Second, a long lapse of time. You can't sit on it for years and then decide you want out. Third, if restitution is impossible, meaning you can't put things back the way they were. Maybe the thing you bought was destroyed or used up. And finally, if an innocent third party now owns the item. The law isn't going to punish another innocent person just to sort out your problem.
So there you have it. From a bit of harmless sales puff all the way to outright fraud, the law of misrepresentation is really about drawing that line between convincing someone and conning them. So the question I'll leave you with is this. Now that you know the rules of the game, where have you seen a potential misrepresentation in your own life? Can you spot the difference?